Welcome, everyone, to the New York State Bar Association's virtual public hearing entitled Social, Practical, and Legal Challenges in Current Immigration Law and Enforcement. I am Karen Anderson Ponzer. I am the chair of the Committee on Immigration Representation and the coordinator of the Immigration Working Group of the New York State Bar Association. The mission of the Committee on Immigration Representation is to improve the quality and availability of legal representation in immigration court, including expanding access to universal representation for all at risk of deportation, and to address the barriers in the immigration system and intersecting legal systems impacting access to justice for immigrants. The Immigration Working Group brings together attorneys with experience in civil and criminal practice across the Bar Association, committed to providing informed legal analysis and education on immigration law, promoting fair and humane immigration policies, and serving as a platform for dialogue and the exchange of ideas among attorneys whose clients serve immigrant communities across New York State. Today's hearing is central to the mission of both the Committee on Immigration Representation and the Immigration Working Group, as it is an important part of our effort to better understand and to document the many ways recent changes in immigration law and enforcement are impacting the legal profession and the communities we serve. The testimony we receive today and written testimony that we will accept until December 1st will be incorporated into a report that we hope will be a resource for attorneys, advocates, and policymakers in support of our efforts to protect access to justice, due process rights, and the rule of law. We're fortunate to have an exceptional panel of speakers today who can bring a breadth of expertise and perspectives in immigration law and practice. I want to thank each one of them for participating today. I can't do justice to the expertise and experience that each brings in the time that we have, but I'll briefly introduce each speaker at the start of their remarks and then just let them get started. Each speaker will speak for about 8 to 10 minutes, thereabouts, maybe a little bit more, but we're going to make time for 1 or 2 questions after each speaker, and we may have some additional time at the end for questions if time permits. Thank you so very much for being here today. And at this time, one thing I'd like to say before I introduce our first speaker is that chat is disabled. Please put your questions in the Q&A box, which we'll be monitoring. Okay, thanks so much. With that, I'd like to introduce our first speaker, Christine Fecco, the Executive Director of the Iola Fund of New York.
Thank you. New York State Bar President Kathleen Sweet, Karen Anderson Posner, Chair of the State Bar Committee on Immigration Representation and coordinator of the State Bar's Immigration Working Group, members of the Immigration Representation Committee and Immigration Working Group, and all leaders of the State Bar. Good afternoon, and thank you for the opportunity to testify. As Karen said, I'm Christine Fecco, the Executive Director of the Interest on Lawyer Account Fund of the State of New York, commonly known as Iola or the Iola Fund. I'm also a member of the State Bar's President's Committee on Access to Justice and the State Bar's Committee on Legal Aid, as well as the New York State Permanent Commission on Access to Justice. Iola is a public fiduciary fund dedicated to supporting civil legal aid organizations across New York, which we do primarily through general operating grants. Iola currently supports 87 nonprofit civil legal aid providers. In fiscal 25, the Iola Fund distributed over $60 million in general operating support, which is expected to grow to over $77 million in fiscal 26 and $95 million in fiscal 27. The New York legal services sector employs over 5,700 people and coordinates over 40,000 pro bono volunteers. In fiscal 25 alone, Iola funded organizations served over 1.1 million New Yorkers and closed over 330,000 cases, from housing and family safety to immigration, consumer protection, and public benefits. Today, I want to focus on immigration legal services, an area where the stakes are especially high and the risks are growing. I intend to speak on 3 points. First, I want to describe and provide data on immigration legal services in New York. Second, I want to share some data and observations about the impact of federal funding cuts and restrictions on immigration legal services in New York. Third, and perhaps most importantly, I want to lift up the efforts of the frontline immigration advocates in New York. First, allow me to describe the immigration legal services landscape. In fiscal 25, 54 IOLA grantees provided immigration services, and in total closed over 67,000 immigration cases that benefited nearly 140,000 people. The data we've collected from fiscal 25 shows the breadth of legal needs facing immigrant communities. So let me break down that 67,000 case number. This work included over 2,500 immigrants obtaining citizenship. In more than 9,000 cases, IOLA grantees secured an adjustment of status or non-immigrant status, which includes asylee and refugee cases, cases under the Special Immigrant Juvenile Program, cases under VAWA, DACA, and TPS, cases obtaining T and U visas for trafficking and crime victims, as well as others. In nearly 7,000 cases, employment authorization was secured without any other relief. Pausing here, I'd like to just note that the services I've described, which amounts to 18,000 cases, resulted in clients having the ability to work legally in New York. Coming back to the total work provided in fiscal 25, there were also nearly 1,300 cases where IOLA grantees successfully canceled a removal, administratively closed an EOIR proceeding, or secured a release from detention by Immigrant and Customs Enforcement, or ICE. Notably, releases from ICE detention is often for survivors of domestic violence or individuals with medical vulnerabilities. In addition, IOLA grantees completed 1,500 full immigration screenings, which determined that the client did not have any available immigration relief, which is an important service. This conclusion, which is offered by reputable legal aid attorneys, likely prevented desperate clients from paying fraudsters that prey on vulnerable communities. Finally, because IOLA grantees do not have the necessary staffing to provide full representation to all of the clients who make it to their doors, in over 46,000 cases, they provided extended advocacy, brief advice, and other services, which is especially important to those with no immediate relief or other options. The consequences of all this work are not just legal, they are economic. IOLA annually conducts an economic impact analysis of the cost savings and financial benefits of civil legal services in New York State. We rely on data reported by IOLA grantees and relevant research to calculate the monetary value of legal outcomes achieved each year. According to IOLA's fiscal 25 economic impact study, immigrant legal services in New York State generated over $900 million in financial benefits, virtually all of which is due to clients receiving increased wages from attaining citizenship and work authorization from those 18,000 cases I mentioned earlier. Being able to work legally means higher wages for clients and their families, often allowing them to lift themselves out of poverty and pursue the American dream. Higher wages also mean higher tax collections for the state of New York and more money being spent in local communities on food, housing, clothing, and school supplies. For these reasons, the outcomes from the effort of the civil legal aid community are not just legal victories. They are lifelines for families, workers, and communities. And these lifelines are under threat, which brings me to point number 2. Federal funding cuts and restrictions will have a profound effect on legal services delivery in New York. In fiscal 25, IOLA grantees received $137 million in federal support, including $34 million from the Legal Services Corporation, now slated for total elimination in the president's executive budget. 20 legal aid organizations in New York rely on federal funding for more than 20% of their budgets. Providers in Western New York and New York City are at particular risk from the loss of federal funding. Western New York has a high concentration of federal funding, with 5 large nonprofit providers receiving up to 27% of their funding from federal sources. In New York City, there are 27 providers that face uncertainty due to the federal threats tied to sanctuary city status, which could eliminate all federal dollars. With respect to immigration legal services, federal funding supports a wide range of services, including Know Your Rights trainings, community education, representation in deportation proceedings, adjustment of status, work authorization, and employment-based relief, as well as defense against wrongful detentions and removals and other cases. Cuts from the U.S. Department of Justice, Health and Human Services, and Housing and Urban Development are already impacting refugee resettlement, domestic violence advocacy, and asylum defense. News of federal funding cuts is hazy and complicated by competing court injunctions and appeals. IOLA's understanding of the data, however, leads us to estimate that of the $137 million, up to $80 million in funding to New York civil legal services nonprofits, at least 20 of which supports immigration legal services, is at significant risk of loss, leaving tens of thousands without representation. The timing of these cuts is unclear. Some cuts have already happened, some are pending challenges in court, others are likely to come in the fiscal 26 federal budget, whenever that may pass, and others may be felt in future years. IOLA has committed over $560 million in general operating support over the next 5 years, but more is needed to address the large and growing demand, and we cannot replace the scale or stability of the federal investment. IOLA strongly supports guaranteed legal counsel for immigrants facing deportation and expanded state immigration defense infrastructure. In addition to reduced funding, recent months have seen sweeping changes in federal immigration policy, including intensified enforcement in public spaces and the termination of programs that provided lawful status and work authorization. Moreover, grantees report that restrictive federal immigration policies have eroded their pro bono partnerships and reduced the capacity of clinic models to serve as many clients as before. These shifts reverberate across civic, religious, and healthcare organizations, raising urgent questions for state and local officials, employers, and the attorneys who advise them. Finally, point 3. I want to lift up and thank the frontline legal staff. The work I've described reflects not just legal complexity, but human urgency. As I'm sure you'll hear more about later today, legal service providers are literally on the front line. IOLA grantees accompany clients to court, ICE check-ins, and detention hearings, often putting themselves at risk of arrest or physical harm in an effort to prevent wrongful detention. They are bearing witness to the trauma experienced by clients ripped away from their children, detained without cause, and deported in the middle of legal proceedings. These scenes, The videos of families separated in real time that the public sees on the news and in social media, they haunt the attorneys and advocates that make up the nonprofit sector in New York. And yet these providers persist. IOLA's grantees have moved community sessions and know your rights trainings online to protect client privacy. They are bringing class action and other impact litigation to challenge illegal and unconstitutional conduct. I just want to shout out Latino Justice was just in the news this week with a huge victory, holding Suffolk County accountable for its wrongful detention and medical neglect of immigrants in its custody. Every day, in small and large ways, IOLA grantees continue to show up, hold space, and fight back. I want to thank everyone for doing this work. IOLA is committed to supporting not only the legal outcomes, but the emotional resilience of the sector. The speakers who follow me today reflect the breadth of response required. They lead with evidence, equity, and resolve, and are among the best of New York's legal profession. I urge the State Bar to support expanded state funding for immigration-related legal services, the integration of legal aid into public safety and justice planning, and the promotion of interagency coordination. Civil legal services are a vital safeguard to the integrity of our justice system and the well-being of immigrant families. IOLA stands ready to partner in building an evidence-based response to the legal, social, and economic challenges posed by current immigration enforcement. Thank you for your time, and thank you for your ongoing commitment to justice for all New Yorkers.
Thank you, Christine. I'd like to introduce our next speaker, Marianne Therapel, Chief Program Officer of the Immigrant Justice Corps.
Thank you, Karen. Good afternoon, and thank you to the Committee on Immigration Representation for the opportunity to testify today. My name is Marianne Therapel, and I'm the Chief Program Officer for the Immigrant Justice Corps, IJC, the nation's first and only fellowship program dedicated exclusively to expanding access to high-quality immigration legal representation. Founded by the late Judge Robert A. Katzman of the Federal Second Circuit Court of Appeals, IJC galvanizes the country's most talented law students and college graduates. We place them with premier legal service providers and community-based law organizations nationwide. We leverage the latest technologies. We offer in-depth and ongoing access to substantive as well as professional wellness trainings. And most importantly, we foster a culture of creative thinking that produces new strategies to reduce the justice gap for immigrant families, ensuring that immigration status is no longer a barrier to social and economic opportunity. Over the past 11 years, we have placed more than 500 of our fellows nationwide, including well over 100 IJC fellows, attorneys, advocates, and alumni, currently serving thousands of immigrant New Yorkers today. You'll hear from some of them as well. We partner with nearly 50 New York legal service providers, addressing critical access to justice gaps through pipeline capacity building, focused on resiliency retention, so that every immigrant facing removal in our state has counsel. Our connectivity to every ABA law school in the country, targeting talent towards demands for representation, allows IJC to build on foundational infusions across this state, developing and sustaining community legal access programs throughout the Hudson Valley, tripling the number of attorneys serving immigrant youth on Long Island, and meaningfully expanding representation capacity for immigrants detained in New York City and upstate New York, and New York detainees who are transferred to New Jersey, Louisiana, and beyond. Our work gives us a unique perspective on the social, practical, and legal challenges created by the current federal immigration enforcement landscape. Over the past year, intensified enforcement, particularly the expansion of expedited removal, mandatory detention without bond, and the targeting of sanctuary jurisdictions has deeply disrupted both our clients' lives and the lives of the fearless advocates committed to this delivery of critical legal services. In New York, we are seeing more clients detained without access to counsel, an alarming increase in family separation impacting U.S. citizen spouses and their children, and greater fear in immigrant communities, discouraging people from attending court hearings, reporting crimes, or seeking necessary medical care. Attorneys are managing rapidly changing policies while working with traumatized clients and dwindling resources following severe loss of federal access to legal programming that has impacted every single immigration legal service provider and private bar immigration attorney in our great state. This instability causes a brain drain of seasoned talent, a chilling effect to enter this field, severe secondary trauma to advocates, and a dramatic decline in the quantity and quality of representation present for immigrant New Yorkers and their US-born families. The result is a widening justice gap that threatens due process for every New Yorker. IJC also would like to note the severe strain these policies place on the broader ecosystem of service providers, including social workers, educators, faith leaders, and healthcare professionals, who must now navigate overlapping legal and humanitarian crises in their daily work. It must be said, many of New York's immigration field advocates and leaders, legal, social, community, and elected, are immigrants themselves, first generation, or a member of a mixed status family, myself included. New York was built by immigrants, is served by immigrants, is sustained by immigrants, and must step up for immigrants. IJC's policy and practice recommendations include that New York State should continue to invest in expanding universal access to immigration representation, including programs that fund both attorneys and DOJ-accredited lawyer representatives. Greater investments in the Office for New Americans programming that meet the rising costs associated with zealous representation and that allow legal service providers to continue to pivot to meet evolving community demands must be a priority. Non-lawyer advocates are essential to meet the scale of need and to ensure culturally and linguistically competent services continue as time-tested sources of access to information through ONA's models. The state should continue to deepen its commitments to immigrants detained in New York, particularly with rampant unlawful interior enforcement reports across the state, and to protecting them from unlawful transfers that impact continued counsel. New York State must push to lead legislation protecting every New Yorker, ensuring that no immigrant child in our state ever faces a judge alone. New York's immigrants' due process rights in New York courts should not hinge on who is in the White House. The Access to Representation Act, ARA, and the BUILD Act are essential legislation for upholding due process in New York and ensuring that decades of justice system access building are not lost to one federal administration's actions. Just this year, IJC received nearly 300 applications from interested candidates dreaming of serving as a Justice Fellow, coupled with over 90 applications seeking over 100 Justice Fellows from host organizations. The demand for quality representation in immigration courts is on every news screen and social media outlet. New York State's legal service providers are one of the strongest, if not the leading, network for access to justice in America. Imagine statewide funded fellows paired with New York providers and firms committed to closing every justice gap the New York way. We also urge sustained investment in substantive training, professional development, and peer mentorship for state-funded advocates because of rampant policy changes impacting zealous representation at every level of legal services for immigrants. With New York State providers representing more immigrants annually, while interior enforcement tactics evolve beyond lawfulness. This requires substantive and practical skills training dissemination to be readily available as well as easily accessible, Substantial funding instability at the federal level impacts the national networks of providers known as the Unaccompanied Children Program. It includes the evisceration of the 13 federally funded immigration court help desks, and we're all watching the continued dismantling of legal orientation programs. This environment creates the perfect playground for well-meaning community members to lean into the unlawful practice of immigration law and for unscrupulous players to take advantage. Relatedly, the inevitable subsequent layoffs of legal managers, supervisors, frontline staff, case managers, and social workers, all of whom have dedicated their careers to this field of practice, results in gaps in leadership, in supervision, in mentorship, in training, in shadowing, and of course, in service. This impacts the retention of existing staff, morale at every level, individual client experiences, and of course, overall legal outcomes. The state and our auspicious bar know the power of legal training and legal technical assistance as crucial sources for substantive strength, solidarity and service delivery, cohesion and policy advocacy, and most importantly, community in practice. Effective examples include ONA's Liberty Defense Project Pro Bono Network, the New York State funded Upstate New York Immigrant Family Unity Project, through which IJC provides legal training and technical assistance for upstate detained providers, and IJC's recent partnership with the Mayor's Office of Immigrant Affairs to train advocates on special immigrant juvenile status cases for vulnerable children entering New York schools. Continuing to invest and expand networks that foster learning, growth, and community amongst legal practitioners and human service advocates ensures strength in our bar, community amongst our attorneys, and ethical practices for our clients. The ARA and the BUILD Act represent foundational investments in New York's legal infrastructure. They are not merely immigration measures. They are due process measures. Together, they affirm the principle that access to counsel is indispensable to the fair administration of justice. When any individual stands before a court without representation, particularly in proceedings as complex as immigration court, the integrity of our justice system is diminished. When detained individuals lose access to counsel due to transfers or funding shortfalls, we risk not only violating their rights, but our collective commitment to equal justice under law. The ARA ensures that no child, no parent, no New Yorker will face a judge alone. The BUILD Act strengthens the legal services infrastructure necessary to make that guarantee meaningful through sustainable investment in training, mentorship, and institutional capacity building across the state. These acts uphold a legacy of leadership that has long defined the state of New York. When the federal landscape becomes uncertain, this state ensures that the rule of law remains certain. Intensified immigration enforcement not only strains the legal system, but it also destabilizes the social fabric of immigrant communities. Expanding access to counsel and community-based advocacy is both a legal necessity and a moral imperative. I urge this bar and our state to advance these measures with the clarity and conviction that due process demands. In doing so, we reaffirm New York's role as a national standard bearer for justice, one that protects the integrity of our courts, the dignity of our advocates, and the rights of all who seek protection within our borders. Let us affirm through these acts that due process is not a privilege to be earned, but a promise that this state keeps. Thank you all for your time today and for the opportunity to share IJC's perspective.
Thank you so much, Marianne, for your remarks. Next, I would like to introduce you to Carla Ostolaza, who is the Managing Director of Bronx Defenders. Welcome, Carla.
Thank you, Karen. Good afternoon, and thank you to the New York State Bar Association and the Immigration Committee for the opportunity to speak today. My name is Carla Solasa, and I'm the Managing Director of the Immigration Practice at the Bronx Defenders, a holistic public defender office in the South Bronx. Nearly a third of Bronx residents were born outside the United States. Each year, our team provides immigration screenings, risk assessments, and full legal representation in immigration matters to more than 2,000 immigrants with pending criminal and family regulation cases in the Bronx. We also co-lead the New York Immigrant Family Unity Project, the nation's first universal representation program for detained immigrants. Through NIFOP, we represent roughly a third of the individuals in detained deportation proceedings at the New York City Immigration Court, as well as dozens of New Yorkers detained outside of New York and whose cases are venued in immigration courts in New Jersey and elsewhere. I am here today to testify about the impact on our client population of the collapse of due process in ICE enforcement and in the immigration courts under the Trump administration's mass deportation campaign, and to urge that New York must stop colluding with ICE and instead intervene to mitigate the profound harm being inflicted on communities across the state. Earlier this year, after the federal government invoked the Alien Enemies Act, hundreds of Venezuelans, including two of our own clients, were disappeared into CICOD, a notorious Salvadoran prison, despite having pending asylum cases here in the United States. On March 15th, after a federal court ordered DHS to halt these removals, we allowed ourselves a moment of relief. By the next morning, however, we learned that ICE had ignored the court order and our clients had been unlawfully removed and renditioned to CICOD, where they were held without access to counsel or their families for months until they were repatriated to Venezuela, the very place they escaped from to seek asylum in the United States. While the rendition of Venezuelans to El Salvador, who were actively seeking asylum before immigration courts, is the most visible and shocking example of ICE's determination to circumvent due process in favor of swift deportations, this was not an isolated incident. It was a preview of what was to come in the following months. Since then, unlawful ICE arrests, incommunicado detention, unpredictable transfers to faraway detention centers, third country deportations to places where people have no connection, and immigration courts abandoning any semblance of neutrality to instead facilitate ICE's mass deportation campaign have all become defining features of the current immigration system. We are facing new patterns of ICE arrests and detention that are more aggressive and destabilizing than ever. For months, ICE has been conducting mass arrests in immigration courts and at routine ICE check-ins. People who have done everything the government has asked them to do, who are complying with the court process, are being detained regardless of the status of their case in court. ICE has also intensified the practice of long-distance transfers without notice. Immigrant New Yorkers are taken from their homes, their neighborhood streets, or from immigration court hearings and ICE appointments, transferred out of state and cut off from their attorneys for days at a time. Sometimes these transfers happen shortly after detention, and sometimes they happen months into the case. Either way, families have no idea where their loved ones are. In several of our cases, attorneys have not been able to confirm a client's location for nearly a week. These transfers create emergency situations where counsel must scramble to determine whether a client is merely being moved or is in the process of being unlawfully removed before their case concludes or sent to a third country without an opportunity to express fear of persecution or torture. One of the most alarming and structurally consequential developments fueling this mass deportation machine is the rapid expansion of collaboration agreements between ICE and local governments. At the beginning of this year, New York had just one 287G agreement in place. Today, there are 10. These agreements deputize local officers to act as federal immigration agents, dramatically expanding ICE's reach. New York State has also expanded the use of IGSA agreements, contracts that expand immigration detention by opening up local jails to be used by ICE. And we know, both from ICE's own data and independent research, that the availability of local detention space is one of the strongest predictors of who gets detained. When a locality opens detention beds, ICE fills them almost immediately. Communities near these facilities experience sharp increases in arrests, and longtime New Yorkers find themselves newly vulnerable simply because detention space has become available. In our area, we have seen how the detention capacity created by the Nassau County's IGSA agreement has turned the local jail into a staging facility where ICE detains New Yorkers without access to legal calls or visits until they are transferred across the country. This is a material way in which New York State has become a collaborator with ICE's unlawful tactics in pursuit of its mass deportation campaign. Nassau County has also entered into a 287G agreement. This overt collusion with ICE has created fear for immigrant community members of engaging with government institutions and law enforcement, fearing that any contact could result in detention and deportation. This immigration detention and deportation landscape takes an unspeakable toll on New Yorkers. Families are separated suddenly and without warning. Children are left without caregivers. Breadwinners disappear into detention, triggering eviction, food insecurity, and unemployment crisis. Fear pushes community members away from hospitals, schools, social services, and even the courtrooms where they are supposed to defend their rights. And the people most deeply harmed are overwhelmingly Black, brown, low-income New Yorkers living at the intersection of policing, poverty, and immigration enforcement. New York has the ability and the responsibility to respond. We should begin by passing New York for All, which will limit local law enforcement collaboration with ICE and all 287G agreements and prevent municipalities from serving as pipelines into the detention and deportation system. And we must pass dignity not detention, which will end local detention contracts with ICE and prevent the construction or expansion of immigration detention facilities in our state. Reducing the number of IGSA agreements and limiting local facilitation of detention is not only sound policy, it is necessary to protect New York from building an infrastructure that supports mass deportation. New York must also pass the Access to Representation Act, which will guarantee the right to an immigration attorney for all New Yorkers, regardless of income or case posture. Universal representation is one of the most effective due process safeguards we have. By passing New York for All, Dignity Not Detention, and the Access to Representation Act, New York can protect its residents, increase public safety, preserve due process, and prevent the devastating human consequences we're seeing every day. Thank you for the opportunity to testify, and I welcome your questions. Thank you.
Thank you so much, Carla, for testifying today. The next speaker will be Sarah McDowell, Deputy Executive Director for Immigration Projects of Volunteer Lawyers Project of Central New York. Sarah, thank you for being here.
Thank you so much. Hello, my name is Sarah McDowell, and I am the Deputy Executive Director for Immigration Programs for the Volunteer Lawyers Project of Central New York. The Volunteer Lawyers Project of Central New York provides free legal services to clients throughout New York State, primarily serving Central New York and the North Country region. VLPCNY's areas of legal practice include family law, eviction defense, LGBTQIA rights, elder law, economic opportunity legal services, and immigration legal services. VLPCNY's immigration programs provide direct legal representation to clients in Central New York and the North Country. And VLPCNY's pro bono immigration program recruits, trains, and mentors pro bono attorneys to handle various immigration law matters. Immigration enforcement has reached unprecedented levels in recent months, while legal and procedural protections from detention and deportation have been whittled away. Previous enforcement priorities targeted individuals with criminal histories and prior deportation orders. Current enforcement operations target immigrants widely throughout New York State. Many individuals who have been in a legal pipeline for years or who even have lawful status are caught up in raids and arrests. Individual circumstances are given less and less consideration, and extremely vulnerable community members are being swept up in the system. The recent changes in immigration regulations and enforcement have created a climate of fear for VLPCNY's immigration clients. Immigrant clients are scared to leave their homes and have increased anxiety before attending routine biometrics appointments and straightforward USCIS interviews. Clients preparing to appear at immigration court or at ICE check-in appointments often experience significant warranted distress, fearing imminent detention and deportation. Some clients in the process of obtaining lawful permanent residency have decided to abandon their petitions and return to their country of origin because their health was being impacted by the fear and stress of the current immigration climate. Our legal practice has had to pivot to support clients with more family advanced planning and preparation for potential detention or deportation of a parent or spouse. VLPCNY is engaging in more rapid response work and receiving more calls about detention and deportation, while the legal tools to protect clients in these cases have diminished. We lack options to help clients who generally fear returning to the current conditions in countries such as Haiti, Venezuela, or Ukraine, but whose legal options to remain in the United States on a temporary basis are dwindling with the removal of temporary protected status designations and the termination of special parole programs. Eligibility to request a bond hearing before an immigration court has been narrowed down so significantly that many immigrant detainees no longer qualify for bond consideration. Youth who obtain special immigrant juvenile status no longer receive deferred action, employment authorization, or protection from removal while they wait for a visa to be made available so they may apply for lawful permanent residency. Immigration judges are encouraged by the Department of Justice to pre-permit asylum applications, denying applicants the opportunity to fully present evidence and have their case fully adjudicated. In recent large-scale employment raids, such as in Cato, New York, Immigration and Customs Enforcement has collaborated with local law enforcement authorities to execute large-scale operations targeting immigrant workers. The majority of immigrant workers detained in Cato were women. Many were mothers of children who came home from the first week of school to find that their mother did not return home from work. Some workers were breastfeeding mothers of babies who were separated from their children and detained for days. Mothers who were no longer breastfeeding or who had older children were sent out of New York State to detention centers in Louisiana and Texas, where their children could not even drive to visit them. These workers were working difficult factory jobs to provide for themselves and their families. During the raid, the immigrant workers were not given the opportunity to contact their attorneys or to provide proof of their immigration status and paperwork if they did not have it on them. The officers erred on the side of detention first, rather than gathering facts and evidence first. This course of action caused unnecessary trauma to workers and their families and denied the workers their constitutional protections. Clients with approved special immigrant juvenile status petitions who have been released on their own recognizance with active immigration court cases have been detained at ICE check-in appointments and sent out of state away from their support networks and attorneys of record. Our community has been deeply impacted by these changes. Industries and employers are losing workers who are reliable and hardworking. Families are being uprooted with children separated from their parents and facing upheaval and instability at home. The mental and physical health and well-being of affected individuals, their families, community advocates, and legal service providers is being impacted by the extreme stress of this enforcement-focused climate, along with the barrage of messaging portraying immigrants, their attorneys, and advocates with extreme negativity. Immigration law is extremely complex and is now rapidly changing with high stakes for those navigating the legal systems. Immigration legal services programs have been underfunded and unable to meet the increasing need in the community for many years. New federal funding cuts on immigration programs and attacks on law firms providing pro bono immigration services have devastated the ability of immigrants in our community to access the legal services they desperately need to be able to navigate complex immigration laws. We need for New York State to fund legal representation for all immigrants facing removal, and we need for the state to provide enough funding so that we can recruit and retain experienced immigration attorneys to fill these roles. State courts play a crucial role in the immigration system. Youth who have been abandoned, abused, or neglected by a parent may only apply for special immigrant juvenile status if a state court makes special findings as part of a guardianship, custody, or other state court proceeding. Immigrant crime victims who are helpful in the investigation or prosecution of crime against them may have an option to apply for non-immigrant status if a state court judge issues an order of protection or another designated official signs a law enforcement certification. Immigrant survivors of domestic violence often fear seeking protection and safety because the abusive partner threatens deportation. State court is a beacon of hope for survivors who may access orders of protection and divorce and custody proceedings, which open doors for freedom and safety and support the survivor's ability to legalize their status under the Violence Against Women Act provisions. State court judges do not confer any immigration benefits, but their role is essential so that certain immigration processes may even be initiated and considered by federal authorities. Full access to legal services and to the New York State court system are essential to immigrant New Yorkers, especially at this time. It is imperative that immigrants in New York can access our court system without fear of ICE detaining and arresting them at the courthouse. Without these safeguards in place, immigrant victims of domestic violence will be unwilling to come forward to seek an order of protection against their abuser. Parents will be too scared to petition for custody for their children in situations where the child is unsafe and in the other parent's care. Families and communities will be unable to safely rely on the court system to promote justice. Thank you for the opportunity to provide these remarks today.
Thank you, Sarah. Our next speaker will be Esther Lim, Practice Director of Immigration at Her Justice. Thank you, Esther.
Thank you. Sorry, I'm trying to get my video to be the right one.
In solidarity.
Okay.
There you go.
Okay, great. Thank you. Thank you again to the New York State Bar Association and the Committee on Immigration Representation for the opportunity to submit testimony on this critical matter. I am Esther Lim, the Director of Immigration Practice at Her Justice, a nonprofit organization that has advocated with and for women and gender minorities living in poverty in New York City. Her Justice provides free legal assistance to women and gender minorities living in poverty in New York City through a pro bono first approach in the areas of family, matrimonial, and immigration law. We partner with some of the city's largest law firms to train, mentor, and support volunteer attorneys to address the individual and systemic legal needs facing our clients. Since our founding in 1993, Her Justice has assisted tens of thousands of New Yorkers. Among the clients we served, in 2024, 92% are women of color, 85% are survivors of domestic violence, and 3/4 of our clients were born outside the US, coming from 103 countries around the world. Her Justice has long served immigrant New Yorkers, building a specialized immigration practice representing undocumented survivors of domestic violence, sex trafficking, labor trafficking, and other forms of gender-based violence. Her Justice offers a full range of direct immigration legal services to meet clients where they are on their legal journey, including advice and counsel and richly resourced full representation through our pro bono leverage model. Our attorneys represent survivors and their derivatives across a broad range of remedies under the Violence Against Women Act, the U and T non-immigrant status, and citizenship applications. As recent government directives increasingly attack the fundamental rights and safety of immigrants, regardless of their legal status, we are seeing increased demand for our services, with both new clients seeking assistance and former and existing clients seeking new kinds of support, as even what once felt like secure legal status is now under threat. Before speaking to the impact that changes in immigration regulations and enforcement have had on our legal practice and our clients and the communities we serve, I want to highlight some of the specific changes that are most salient to our clients. This list, of course, is not exhaustive, and we have all felt so many different repercussions from the onslaught of changes that are happening rapidly, but these are the ones that are most salient to our clients. And the first is the change in victim-centered approach to enforcement. The victim-centered approach previously placed equal value on identifying and stabilizing victims of crime, domestic violence, trafficking, and enforcement. So, however, there was a directive early on in the Trump administration that changed the victim-centered approach that ICE officers had practiced in the past. This new directive rescinded 2021 and 2011 guidance that required more prosecutorial discretion when the non-citizen was a victim of a crime. The new approach is for ICE agents to coordinate and deconflict internally with local, state, and other federal law enforcement. There is no requirement to affirmatively seek indicia or evidence suggesting a person is a victim of a crime or consider such evidence as a positive discretionary factor in determining enforcement action. There has also been a decrease in the prosecutorial discretion as everyone is a priority. I think others have also mentioned this previously, and the heightened risk of mandatory detention under the matter of Uri Hurtado and the Lake and Riley Act, the reinstatement of the matter of AB2 and LEA2, which basically proclaims that domestic violence victims are no longer considered a particular social group for asylum purposes. The proposed rule to eliminate the automatic extensions of employment authorizations, the increasingly long adjudication times from USCIS, and the delays in receipt notices from USCIS, also the cut in funding for community-based organizations that provide non-legal assistance for our clients, and the increased difficulty in obtaining employment-related visas, as well as increased difficulty in actually even communicating with USCIS. Any one of these challenges would have been detrimental, which would have had detrimental effects to our clients. But when all these changes happen at the same time, the results are 1,000 times worse. The heightened focus on detention and deportation and the change to the victim-centered approach have had a devastating impact on the safety of our clients and their well-being, as well as for the safety of communities at large. The UT and VAWA statutes not only protect the victims of domestic violence and other enumerated crimes, they also protect the communities at large because crimes that are committed in these communities are being reported. However, due to this hyper-focus on detention and deportation, our clients who are victims of domestic violence, sexual assault, trafficking, and other enumerated crimes are fearful to seek assistance from law enforcement or the courts that are there to protect them. Threats by assailants to report them to ICE has become a very real fear. ICE has come to our clients' doors looking for them or others in the household. ICE presence in and around the courthouses have had a chilling effect on our clients seeking orders of protection, something they desperately need in order to be safe from their abuser. In 2020, New York State passed the Protect Our Courts Act, which aims to ensure all New Yorkers, regardless of immigration status, can access the courts without fear of immigration enforcement. However, in June 2025, the Department of Justice sued New York State to stop the act, once again preventing individuals from accessing justice for fear of ICE encounters and enforcement. Aside from the very public show of force by ICE and CBP, the not-so-public changes that are happening within USCIS practice and BIA decisions have been even more detrimental to our clients. Increasingly long adjudication times and delays for recent notices from USCIS have left our clients in legal limbo. Our clients are unable to access benefits which they are entitled. Coupled with this is the decreasing pathways in which to communicate with USCIS. On average, we need to try 3 or 4 different methods to get any response from USCIS on any inquiry. This includes email, USCIS web portal, phone calls, USCIS Ombudsman's Office, and Congressional Liaison Assistance. Her Justice knows that our immigration clients and all immigrant New Yorkers make remarkable contributions to and are part of the very fabric of our city. In 2023, Her Justice published a policy research report called Stories from Immigrant Survivors of Gender-Based Violence, the Impact of Work Authorization, which brings forward the experiences of immigrant survivors seeking legal permission to work in the United States and explores the impact on their lives as women, mothers, and workers of obtaining work authorization. Our findings highlight that most clients are mothers supporting families and contributing to New York's economy, yet many still work without legal protections matching their values. Our research found long delays in EAD approvals and severe economic insecurity among survivors, with many unable to leave abusive partners due to financial dependence. We believe our research demands a commitment from policymakers to address the needs of all undocumented immigrants for safe and secure employment, especially immigrant survivors like those featured in this report who lived in the US for years without legal right to work to support themselves and their children while seeking safety from abuse. The recently proposed rule to eliminate the automatic extension of employment authorizations are putting clients' jobs at risk and therefore their livelihoods. These are for individuals who are entitled to work under the immigration laws. We urge the Bar Association to advocate against the rule change and keep immigrants' access to employment authorization secure. Additionally, the reinstatement of prior BIA decisions, as I just mentioned, that concluded domestic violence victims are not a particular social group for asylum purposes has had disastrous effects for our clients and communities. Individuals who filed domestic violence-based asylum claims years earlier and had been waiting to have their cases heard have had their cases pre-terminated and orders of removal issued once they finally get in front of an immigration judge. Our clients are now at risk of being deported to countries where they face grave risks and violence. Additionally, we and our clients rely on other non-legal service providers for social services such as mental health counseling, employment counseling, and navigating other systems that help survivors on their road to recovery and self-sufficiency. Many of these organizations provide culturally and linguistically specific services for survivors. The cut in funding to the community-based organizations who provide non-legal services to immigrants, coupled with the ever-increasing restrictions on obtaining an employment-related visa, has resulted in staff at these community-based organizations being cut, which means our clients' non-legal services needs are not being met. The broader effect of this is attorneys representing clients have been pulled into areas where they are not experts, trying to navigate systems and stabilize the client's life. This administration continues to characterize domestic violence and other forms of gendered violence as private conduct, returning to an outdated concept that such abuses are no concern of the state. This logic is used to protect abusers from accountability and force survivors into the shadows. This undermines the backbone of the VAWA and UNT laws that were designed to keep communities safe by including the state. It is imperative that we continue to protect access to justice by making sure that the Protect Our Courts Act continues despite the attack from the administration. We need to advocate with state and federal legislators to pressure the USCIS to keep an open path of communication and not put up arbitrary roadblocks for our individuals seeking status. And her justice's commitment to advocating for a more equitable immigration system is informed by the experience of immigrant survivors of abuse, and we call for their needs to remain a priority in immigration reform and in city and state efforts to protect the rights of immigrant New Yorkers. Thank you again for your time.
Thank you so much, Esther. Our next speaker will be the Reverend Paul Fleck, Executive Director of Immigration Law and Justice, New York.
Thank you, Karen. I apologize for my throat. It should get clearer as I speak. I want to thank the New York State Bar Association and the Committee on Immigration Representation for the opportunity to have this forum. Immigration Law and Justice New York provides humanitarian and family unification immigration legal services generally. It is a tiny not-for-profit with offices in Manhattan and Long Island with aspirations of being a larger not-for-profit. I also want to say parenthetically that I'm proud to share this hearing with Christine Feckel of IOLA. I really can't understate the tremendous benefit that an independent and forward-looking IOLA fund has had on our small nonprofit. And I encourage the New York State Bar Association to continue to preserve its independence from the state legislature and the governor, and quite frankly, seek to prevent the legislature and the governor from raiding the IOLA fund as if it's their own piggy bank. I was asked in preparation for my remarks to describe what impact the challenges and changes in immigration regulations and enforcement have had on our legal practice and the clients and the communities we serve. Quite frankly, we found that the throughput of cases, that is the resolution of them, has become much more difficult. Everything takes that much longer. I can only really provide a few anecdotal examples of how our attorneys have been distracted and taken away from the merits of the cases to handle things that this administration has thrown in their way. For example, my managing attorney, TJ Mills, had to produce a 4-page memo of the pros and cons of compliance with the immigration registration requirement and send it out to each of his current and former clients so they can evaluate whether or not to register. My senior staff attorney was notified of an ICE check-in for a client in removal proceedings whose case was a relatively straightforward special immigrant juvenile status case along with an asylum claim. And so she went ahead and back when there was bond available, she prepared a motion for potential bond, a motion for stay from deportation because she was afraid that the client might be detained. She contacted Congressman Espaillat's office, who, if you know of his background, is a formerly undocumented individual himself, and sought his intervention. And then she stood in line with that client to determine whether or not they were going to be detained and what were the relative consequences associated with this ICE check-in. And she got to the front of the line and she was presented a notice to appear some months into the future. And she got back to the office and she said, you know, they could have sent this in the mail like they usually do. And I think that just underscores that the tentativeness and the trepidation that this administration wants to strike into the hearts of immigrants and practitioners is very real, and that the cruelty of this administration really is the point, as the Atlantic magazine has said. So the consequences of these changes to our community that we're serving and the broader impacts has been that we've had to decrease the number of clients we're taking in on the front end. Instead of 8 clients per clinic, for example, we're taking half as many, we're taking 4. Each of our current attorneys have in excess of 100 clients, which is simply untenable for a single attorney each. But we continue to soldier on in this environment because, again, we're not getting resolution of these cases. They aren't being taken care of on the back end, and we can't take any and continue to do so on the front. I've been asked what recommendations I would have for legal or policy solutions to respond to or mitigate these challenges. Pass the Access to Representation Act. Pass the BUILD Act. Increase the bench of immigration lawyers out there in the community who can respond and can represent these clients who are in desperate need of representation. I think Rosie Wang is scheduled from the Vera Institute to testify on this, but I think the representation of clients in immigration courts has actually fallen over the last few years from about 40% to about 25%. There's a desperate need to increase immigration attorneys and immigration representation for clients in removal proceedings and elsewhere. One thing that we notice as a small immigration nonprofit is our attorneys aren't trained or knowledgeable in practice in district court for habeas proceedings. We could certainly use a bigger bench in terms of having trained lawyers in habeas proceedings who can assist us in that area as well. And then finally, as someone who tries to resource our attorneys, in particular, as an executive director, I would increase legal funding without onerous reporting requirements. And I know that seems rather trite, but I would say, for example, we recently had a city contract. We don't have a city contract, I should say. We got a city award and of $300,000. We're a small nonprofit and we want to utilize that. And they said, begin spending immediately. And I said, well, we really can't begin spending until we have some of the money, and they only spend they only provide the funding in arrears, and it became quickly apparent that we weren't going to be able to get a bridge loan from the Fund for the City of New York for 25% of that amount unless we had a city contract in place. So at one of these gatherings, I asked, how soon can we get a city contract in place? And they said, oh, it's going to take a minimum of 4 months. So they wanted me to spend in arrears starting July 1st for an award that was awarded in August. I still don't have a contract. I could spend my organization into the ground before I ever saw $1 from the city. I think the same could be said for state funding in arrears. And I would support the Paul and Mayer bill that would encourage less red tape and provide more funding up front to providers. Finally, one thing on a personal level for some of my attorneys, and I think other attorneys entering into this field, is they've been targeted as if their activities are illegal. And because of that, they've sought to rescind public student loan forgiveness for immigration legal service providers. The regulation is being published for comment, and I would encourage the state bar to strongly oppose this attack on some of our youngest immigration legal service providers who have hundreds of thousands of dollars in public student loan debt. Thank you for this opportunity to testify.
Thank you, Paul. Our next speaker will be Carmen Maria Ray Caldes on behalf of the Association of Former Immigration Judges.
Hi, good afternoon, everyone. Just before I start, there are a series of undersigned judges whose names will appear in our written testimony on whose behalf this testimony is being provided. This testimony is being offered on behalf of the undersigned former immigration judges who served in immigration courts located within New York State. We've drawn upon their combined decades of expertise in drafting this testimony, which is an excerpt from the written testimony submitted into the record. The United States has benefited from a formal, centralized process in which federal officers determine whether to exclude or deport non-citizens for approximately the last 144 years. Except in limited circumstances, since 1983, non-citizens within the territorial boundaries of the United States who lack immigration status or who are accused by immigration authorities of having violated the terms of an immigration status have had the statutory right to receive a formal hearing before an immigration judge, commonly referred to as a removal hearing. Detained non-citizens can also request a custody redetermination hearing so that an immigration judge may determine whether the non-citizen should be released from detention during the pendency of his or her immigration case or must remain detained while their case winds its way through the courts. There are currently approximately 600 immigration judges sitting at approximately 70 immigration courts across the United States. Those immigration courts are part of the Executive Office of Immigration Review, EOIR. Decisions made by the immigration judges at those courts can be appealed to the Board of Immigration Appeals, the BIA. Both the EOIR and the BIA are part of the United States Department of Justice, the US DOJ. All immigration judges at EOIR and appellate immigration judges at the BIA are employees of the US DOJ. New York State presently houses 6 immigration courts. Of those, the Ulster Immigration Court, in Napanoch, New York, and the Batavia Immigration Court in Batavia, New York, exclusively hear cases of non-citizens who are detained, while the Varick Immigration Court in New York City hears a mixed docket comprising both the cases of non-citizens who are allowed to remain free from custody while their immigration cases proceed before the court, and those who are taken into custody and must argue their cases from within the confines of a detention facility. All other immigration courts in the state hear cases exclusively of non-detained non-citizens. In these 6 courts, approximately 78 immigration judges decide cases for hundreds of thousands of foreign-born New Yorkers. Those immigration judges are responsible for determining first whether an individual non-citizen is subject to the court's authority. That is, if the Department of Homeland Security can establish that they are in fact a non-citizen or in legal terms an alien to the United States. And second, whether the non-citizen may be able to obtain or retain immigration status in the United States. The immigration courts have been the subject of long-standing complaints of long delays, poor quality in adjudications, and increasingly politicization. Under the guise of addressing some of these long-standing concerns, the Trump administration has instituted a series of changes to immigration agencies, immigration courts, and the Board of Immigration Appeals that have already resulted in a substantially larger percentage of non-citizens being subject to long-term detention and removal, and in fewer non-citizens being able to appeal even erroneous decisions of the immigration court. The remainder of this testimony will address some of the more pernicious of these changes and suggest methods that may serve to counter them. Of initial concern is that the Department of Homeland Security has issued guidance that will result in every non-citizen whose affirmative immigration case is denied by the United States Citizenship and Immigration Service, USCIS, being placed in removal proceedings. Historically, USCIS has been responsible for issuing immigration benefits to non-citizens who applied to obtain immigration status, everything from applications for lawful permanent residence filed by spouses and children of U.S. citizens to petitions for non-immigrant status filed by victims of crimes have been adjudicated by USCIS. Historically also, a denied application did not result in the applicant being placed in removal proceedings, in part because the agency allowed non-citizens to address errors in adjudication via motions filed with USCIS or by refiling of applications to allow for re-adjudication. This meant that there was little inherent risk in a non-citizen applying for most immigration benefits. This has now changed. As of February 28th of 2025, effectively every denied application will result in the department's filing of a notice to appear before the immigration court to initiate removal proceedings against the non-citizen. This will greatly complicate representation of non-citizens seeking immigration benefits, as attorneys must now be prepared to represent non-citizens in affirmative filings and potentially in removal proceedings. Historically, attorneys who represented non-citizens in affirmative filings were specialists that did not also litigate cases on behalf of non-citizens in removal proceedings. Given the anticipated increase in removal proceedings for this population, attorneys must now be supported in receiving additional training and supervision to be able to successfully navigate complex removal proceedings on behalf of clients. The administration has also issued guidance to immigration judges to govern their handling of cases. Some of this guidance directs judges to adjudicate cases, including asylum cases, within short timelines. Other guidance and corresponding decisions from the Board of Immigration Appeals direct judges to pre-termit cases, in effect denying cases without a hearing, and to stringently apply requirements for continuances, as well as warn judges that they may be fired if they fail to adhere to this guidance, or if their grant rates in cases differ from the average, a factor that appears to have been used by the administration to terminate at least 2 judges in New York City in the last few months. The cumulative effect of these actions is to restrict immigration judges' discretion in handling their caseloads. In particular, the demand that immigration judges must pre-termit applications, decide cases on an expedited timeline, and disfavor continuances will place great demand on immigration attorneys to dedicate an increased amount of time to cases at early stages of proceedings, to ensure that the cases are sufficiently well documented by primary and secondary evidence and legal briefing so as to survive pre-termission, and sufficiently ready to proceed to trial so as to make continuances unnecessary. It will also strain available pro bono resources for the preparation of necessary supporting evidence, from expert witnesses and country conditions to medical evaluators that can attest to the presence of sequelae of violence to corroborate harm suffered by an asylum seeker. Shoring up those resources, those pro bono resources that are relied on by immigration attorneys throughout the state, will become of paramount importance, as will developing similar new resources to enable low-income litigants to have a chance at prevailing on their cases. As has been widely reported in the news, the administration has also sought to detain an ever greater percentage of non-citizens during the pendency of their immigration proceedings by reinterpreting long-standing detention statutes to strip immigration judges of the authority to review the department's decision to detain a non-citizen. As we know, rates of representation for detained non-citizens are much less than those for non-detained non-citizens, and success in immigration proceedings is closely related to a non-citizen's being represented, such that a non-citizen's ability to litigate their case outside of detention maximizes the possibility that they will be able to successfully obtain the right to remain in the United States. Historically, with limited exceptions, immigration judges had the authority to release from detention non-citizens who established that they did not pose a danger to the community or a flight risk. And in September of 2025, the BIA unfortunately issued a decision that stripped judges of that authority in an overwhelming majority of cases. This has created a landscape in which increasingly the sole means for non-citizens to challenge long-term detention is through federal habeas litigation. Unfortunately, even seasoned immigration court litigators are often inexperienced in federal habeas litigation, which is resource intensive and happens before a different tribunal with different legal and evidentiary standards on different timelines. Nevertheless, efforts to train up immigration attorneys to handle these kinds of cases, like the National Immigration Habeas Institute at Cardozo Law School, must be supported to enable the maximum number of non-citizens possible to litigate their cases from outside of detention. At the same time, we must continue to support efforts like the New York Immigrant Family Unity Project, Knife Up, that serve non-citizens who are detained to maximize the possibility that they too will obtain immigration status and the ability to remain part of our communities in New York. Lastly, the administration has increased the cost of appealing an immigration judge decision from $110 to $1,010. Appealing an erroneous decision is the only method that non-citizens have to check an immigration judge's reasoning in their specific case. It serves as the only check on a judge's correct application of law and precedent, and yet the increased appeal fees will serve only to discourage low-income New Yorkers from appealing incorrect decisions made by immigration judges. Lack of financial resources should never present a barrier to accessing justice. To the degree that we can shore up access to resources and filing fee waivers or ability for non-citizens to borrow through authorized means to file appeals, it would help in countering these efforts by the administration to limit access to appeals, as would additional efforts to train up immigration attorneys to handle Board of Immigration Appeals on a pro bono basis. Thank you very much, everyone, for your attention to this testimony. I cede the floor.
Thank you very much, Carmen. Our next speaker will be Jason Whitehead, Associate County Attorney of Westchester County. Welcome,
Hello,
Jason.
good day. Thank you for allowing me to be here. And I want to thank the New York State Bar Association for this program, the Immigration Committee, Karen Anderson Ponzer and Eunice Bank, and staff for putting this program together. I'm here on behalf of John Nona, the Westchester County Attorney, who is charged with overseeing all civil matters for the County of Westchester, its agencies and departments, at the behest of our County Executive, Ken Jenkins. This includes not only civil, trial, and appellate litigation, but family court, including juvenile delinquency, abuse and neglect matters, and Article 81 matters, as well as other matters. Like the institutional defenders and legal service providers before me, the county has no doubt been impacted by the current presidential administration, including, of course, the immigrant community and our undocumented persons. Of course, fear among residents, specifically our undocumented persons, not being able to live freely and conduct their daily lives. For example, obtaining human services, medical attention, attending school, or even going out to their jobs, not being able to report incidents, and also, more importantly, cooperating, or just as important, cooperating with law enforcement. Going to family court, as was mentioned earlier, to obtain relief, domestic orders of protection, things like that. And it's also including the threat. The county has also been impacted by the threat to federal funding for all county resources, not just law enforcement. The challenge and consequence for us is getting undocumented persons to come forward, and also to recoup any funding that's been lost by the overreach of this administration. While the county has not yet been able to quantify the impact of persons not coming forward and exercising a full life, we have no doubt that the actions of this administration is having a detrimental impact on the reporting of crime and people coming forward to obtain services. The Immigrant Protection Act passed by Westchester County Board of Legislators was the county's response to this president's first administration back in 2018. But first, a little about Westchester County. Westchester County is the seventh most populous county in New York State, home to a little over 1 million people. It contains 48 or so municipalities, and many of those municipalities have their own police forces. The Immigrant Protection Act applies to county police only. The locals may have their own policy. While Westchester does not identify itself as a sanctuary jurisdiction, Westchester adopted the Immigrant Protection Act in 2018 to encourage the cooperation and foster positive relations between county residents and law enforcement to improve public safety for all Westchester residents. In drafting the IPA, or Immigrant Protection Act, the Westchester County Board of Legislators, our governing body or legislative body, cited an Illinois study stating that 45% of Latinos were less likely to voluntarily offer information about crimes and are less likely to report a crime because they are afraid the police will ask them or people they know about their immigration status. And that 70% of undocumented persons report that they are less likely to contact law enforcement authorities if they are the victim of crime, which undermines the safety of all Westchester residents. It is on this basis that the Board of Legislators of Westchester County believed and continues to believe that the IPA encourages cooperation with and fosters positive relations between county residents and law enforcement, which ultimately improves public safety for all Westchester residents. The IPA is not designed to, nor does it, interfere with enforcement of federal immigration law. Rather, the IPA ensures the fair and lawful treatment of all residents, regardless of their immigration status. At the outset, it is extremely important to note that the policy promulgated in the IPA does not require Westchester law enforcement agencies to violate federal law. Through the IPA, or Immigrant Protection Act, Westchester has sought to continually and seeks to continually ensure that law-abiding residents are safe and confident providing information to law enforcement. Again, the BOL Board of Legislators sought to ensure residents feel safe in getting medical care, public assistance, seeking redress from family court, criminal courts, etc., and other necessary human services. Now, under federal law, the feds are responsible for immigration enforcement. And although the federal agencies or executive Congress may provide incentives for state and locals to assist in immigration enforcement, those incentives or conditions must be related to the funding. They may not be coercive, and they may not violate the Constitution, particularly the 10th Amendment, the Anti-Commandeering Clause. They may not enforce states and locals to they not force or compel states and local municipalities to enforce immigration law. They may not force state and locales to use their resources to enforce immigration law, unless with respect to a particular set of funding, that those conditions are set by Congress, or Congress has given the executive branch discretion to attach strings. Nor may Congress, and that was the case in Friends of the United States, nor may Congress issue direct orders to states or localities. And that's Murphy v. NCAA, a case in 2028. Immigration law requires states and locales to not prohibit voluntary communication about citizenship or immigration status. However, under the IPA, undocumented persons must receive equal treatment under the law in Westchester County. This is the IPA again. And first and foremost, and important to note, I think you heard about 287G agreements before I started to speak. The county has chosen not to enter into a 287G agreement with immigration authorities to assist them in enforcing federal immigration law. Under the IPA, county employees may not ask about immigration or citizenship status unless required by law, unless required to receive benefits, to be eligible for benefits, or the person being interviewed has voluntarily or has been given informed consent in terms of providing that information. Westchester County employees may not intimidate anyone by threatening to call immigration authorities. And they may not communicate with immigration authorities unless required by state statute, regulation, or a particular court decision. With respect to law enforcement may not, county law enforcement, again, we're talking about county police, the Westchester County Department of Public Safety, may not assist federal immigration enforcement officers, which is consistent with the 10th Amendment anti-commandeering clause, because neither the states or neither the federal government or Congress can issue a direct order to states or localities and cannot force states and locals to use its resources to enforce federal immigration law. Law enforcement may not ask people for immigration status unless required by law. And usually when it's required by law, it usually means that it's a federal immigration crime. Being in the United States, as most of my panel, all of my panel members know, that it's not illegal to be, it's not a crime to be in the United States unlawfully. It's a civil violation. The only time it's a crime is when you've been convicted of a crime and you've been deported and you illegally re-enter the country. That's when it becomes a crime. Or it's required by law to ask for immigration status if there's a probable cause to believe that the individual has engaged in terrorism activity. Again, what law enforcement may not do, law enforcement in Westchester County, again, the county police may not stop, question, or arrest a person based solely on an immigration status. They may not communicate to immigration authorities about a person, again, unless it's required by law, unless it's about a non-immigration related crime, or there's probable cause to believe that the person has illegally re-entered after having previously committed a crime or engaged in terrorism. County police may not allow ICE to enter or access correctional facilities unless there's exigent circumstances. County police may not permit ICE to interview a person in custody unless they have their consent, or unless there's a judicial warrant signed by an Article 3 federal judge, and if there is a judicial warrant or the person is given their consent, the person still must be given an opportunity to consult with counsel. County police may not hold an individual beyond their release date based on a civil detainer. That can only happen if there's a judicial warrant signed by a judge, an Article 3 judge, not an immigration judge, because that person is not an Article 3 judge. And this is because administrative warrant detainer is a civil request. It's not it's not an Article 3 warrant or signed by a judge. And that is also because that police officers in New York State are not authorized to make arrests or detain individuals based on an administrative warrant. And that was a case, a case, I think it was Castaneda, in fact, in a case out in Suffolk County, that the Suffolk County Sheriff's Office was just found liable for a lot of money for holding detainees past their release date or past the date in which they had posted bail. County police may also not interfere, may not help federal authorities enforce immigration law. And county police are not allowed, county police or county employees are not allowed to use local resources to assist ICE or immigration authorities. And the county's action is lawful. We know it's lawful because the case says so, and also because initially Westchester County was actually named by the Department of Justice as a sanctuary jurisdiction And then, of course, the very next day, back in March, they took that list down. And 2 months later, the list reappeared, and Westchester County was not on that list of sanctuary jurisdiction. But even as Westchester County is not a sanctuary jurisdiction, that lawfulness of our policy has still not saved the county. We still under threat. We're still under threat of losing federal funding. In fact, there's been a few grants that the county has not been able to receive because the federal government has been attaching conditions, unlawful conditions, on receiving funding. That funding is related to law enforcement, airport funding, transportation, FEMA. Luckily, the New York State governor and New York State Attorney General's office have been has picked up the mantle, and has, along with other states and municipalities, has sued the administration and have obtained favorable results. In one case, I believe it's a Rhode Island case, there was actually been a preliminary injunction granted, and then also summary judgment was granted, which helped retain funding with regard to transportation and FEMA. But the administration is still unlawfully attempting to impose restrictions on other funding that has nothing to do with immigration enforcement, number one, and conditions that Congress did not impose. In the end, we believe that the county is doing justice and doing good work in terms of trying to protect our immigrant community. And Westchester County thanks the governor, New York Attorney General's office, and the New York State Bar Association for their efforts in protecting immigrant New Yorkers. Thank you.
Thank you, Jason. Our next speaker will be Deborah Lee, attorney in charge of the Immigration Law Unit at the Legal Aid Society.
Thank you and good afternoon. My name is Deborah Lee, and I'm the attorney in charge for the Immigration Law Unit at the Legal Aid Society. Thank you to the New York State Bar Association's Committee on Immigration Representation for this opportunity to testify today. I submit this testimony with my colleague, Hassan Shafiqullah, supervising attorney in the Law Reform Unit of our civil practice. The Legal Aid Society is built on one simple but powerful belief: that no New Yorker should be denied the right to equal justice. We want to remain a beacon of hope for New Yorkers who feel neglected, regardless of who they are, where they are from, or how they identify. From our start nearly 150 years ago, our growth has mirrored that of the city we serve. Last year alone, we served over 480,000 individuals and families across our civil, criminal, and juvenile rights practices. Within our civil practice, the Immigration Law Unit, now nearly 100 staff strong, has provided free, comprehensive immigration representation for almost 4 decades. We represent clients before U.S. Citizenship and Immigration Services, the Executive Office for Immigration Review, the Board of Immigration Appeals, and federal courts. We also partner with community organizations and over 50 pro bono law firms to meet ever-growing demands. Over the most recent fiscal year, our Immigration Law Unit assisted in nearly 8,600 individual legal matters, benefiting over 22,000 New Yorkers citywide. As the administration implements its promise of mass deportations, unleashing over 525 executive orders or policy changes related to immigration since January of this year, our Immigration Law Unit has been responding to the ever-changing immigration legal landscape by developing new Know Your Rights resources, conducting trainings for advocates, and holding limited scope legal clinics to help the most emergent needs, acting in real time to ensure New Yorkers have access to critical information. Our newly redesigned Get Help Hub centralizes more than 100 Know Your Rights resources to one easy-to-navigate digital platform on our public website. The most pressing challenge facing non-citizens today is detention by federal immigration authorities, often without any opportunity for release on bond. Families go days without knowing where their loved ones are, and individuals can remain in custody for months or even years despite favorable rulings. At the same time, the federal administration has launched sweeping litigation strategies aimed at invalidating state and local measures designed to safeguard due process and access to justice. These efforts raise fundamental questions about federalism, constitutional limits, and the rule of law. The remainder of my testimony will address several of the administration's most consequential legal and policy initiatives targeting New York. First, with state courthouses. On January 22nd, 2025, ICE issued a policy memorandum entitled Interim Guidance, Civil Immigration Enforcement Actions in or Near Courthouses, asserting its authority to conduct civil immigration enforcement in or near courthouses, including criminal and non-criminal courts. Initially, the guidance required consistency with local laws. But on May 27th of this year, ICE issued another policy memorandum, removing that language, signaling an escalation in enforcement tactics. Here in New York, we have the Protect Our Courts Act, or POCA, which prohibits ICE enforcement in or around state courthouses. The New York State court system reaffirmed POCA's validity in February. Nevertheless, the DOJ filed a lawsuit, USA v. New York, in the Northern District on June 12th, 2025, seeking to invalidate POCA based on the Supremacy Clause. That suit also seeks to invalidate two New York State executive orders, numbers 170 and 170.1, that prohibit New York State employees from cooperating with federal immigration enforcement. That case is ongoing. Now on to immigration courts. Federal immigration courts are not covered by POCA. On January 28th, the immigration courts issued Policy Memorandum 25-06, permitting ICE enforcement in or near immigration courts. Since May, ICE has arrested individuals attending court hearings, mandatory check-ins, and U.S. citizenship and immigration services interviews. By July, New York City has recorded 460 arrests in immigration courts, the highest in the nation, with arrests continuing unabated. On to driver's licenses. On February 12th, the DOJ sued New York State to invalidate the green light law, which allows non-citizens to obtain driver's licenses if otherwise eligible. The suit alleges violations of the Supremacy Clause again, including preemption and unlawful regulation of and discrimination against the federal government. This litigation also remains ongoing. This administration has also targeted sanctuary cities. On April 24th, 2025, the Department of Justice sued the city of Rochester, seeking preliminary and permanent injunctions against Rochester's sanctuary city policies that prohibit city employees from assisting in federal immigration enforcement. The DOJ alleged that Rochester's policies violate the Constitution's Supremacy Clause by unlawfully regulating and discriminating against the federal government and by passing laws that are preempted by federal regulations. Specifically, the DOJ alleged that the policy violates 8 U.S.C. 1373, which prohibits state and local government from restricting the sharing of information between any government entity or official and the federal immigration enforcement. The case is ongoing. New York City has several laws, passed mostly in 2014, that also make it a sanctuary city. These laws prohibit city employees, including police and Department of Corrections officers, from cooperating with ICE. One of those laws also forced ICE off of Rikers Island, where the agency used to maintain an office. On April 9th, as part of a quid pro quo with the Trump administration, dropping federal corruption charges against him, Mayor Eric Adams issued Executive Order 50, allowing ICE to return to Rikers, allegedly for the limited purpose of investigations related only to intelligence sharing focused on violent criminals and gangs. The New York City Council sued, and in late April, the New York Supreme Court issued temporary restraining orders. The Legal Aid Society and others filed amicus briefs in May. At a June 3rd, 2025 hearing, the court orally extended the temporary restraining order and issued a preliminary injunction in June, and issued a permanent injunction on September 8th, 2025. Mayor Adams filed a notice of appeal on September 16th. On July 24th, 2025, in USA v. City of New York, the DOJ sued New York City over its sanctuary city laws, arguing that the local laws violate the supremacy clause of the Constitution. The case is ongoing. Rochester and New York City are not alone. The administration has also brought similar cases against Los Angeles, Denver, Chicago, and several New Jersey cities. With the election of Zohran Mamdani as the next mayor of New York City, we are expecting redoubled efforts by the Trump administration to target the city for immigration enforcement. The city has already been the target of aggressive raids, like the one on Canal Street on October 22nd of this year. Alongside legal partners and community members across the city and state, the Legal Aid Society will continue to fight against injustices against non-citizens and is actively monitoring federal litigation efforts to see how we can best contribute. We remain steadfast in our commitment to defending New York and New Yorkers, and we will not be intimidated. Thank you very much.
Thank you, Deborah. Our next speaker will be Rex Chen, Supervising Counsel for Immigrant Rights at Latino Justice Pearl Deaf. Welcome, Rex.
Thank you. I'm trying to share my screen. Can you see my screen, Karen?
Yes, I can.
Okay, my name is Rex Chen. My pronouns are he, him. I'm going to cover three main points. I'm going to cover the work that where I work, Latino Justice Pearl Deaf does. I'll talk about a recent victory. Others have mentioned it, a $112 million jury verdict against Suffolk County. And then I'll talk about steps to defend immigrants. I'm also going to leave time for questions, so please use the Q&A function in Zoom to type some questions. All right, first, about the work that Latino Justice Pearl Deaf does. We've been around for over 50 years, and we focus on impact litigation, including cases that raise civil rights and racial justice issues. For example, our immigration cases, immigrant rights are also civil rights, and we are fighting the racism that's been part of immigration law since the very beginning. We are called Latino Justice, but much of our work helps all immigrants, not just Latinx folks. For example, we sued in the Southern District of New York to defend birthright citizenship, which will help all immigrants. Now, second, so that's birthright citizenship. Let's talk about a recent victory. We had a great $112 million verdict. It was just last Friday, November 7th, 2025. The Suffolk County sheriffs illegally detained around 674 people in 2016 to 2018. These are people who completed their time in jail, such as they, for example, might have posted bail or they got all the charges dropped. At that point, Suffolk County sheriffs should have released them, but the sheriffs illegally kept detaining them. What happened was that ICE, Immigration and Customs Enforcement, issued a request that's called an ICE detainer. And they asked the sheriff if they would be nice enough to keep detaining certain people. These polite requests did not give Suffolk County any power to detain anyone. So when Suffolk County sheriffs chose to keep detaining people extra time, they broke the law. In addition, they failed to give notice to the people they were detaining that they were holding them for this extra time because of the ICE detainer, or to give them information of how they could challenge this extra detention. For all these violations, a unanimous jury ruled that they have to pay $112 million. Now, it's very hard to bring these cases. We did it entirely for free, pro bono, and we got critical pro bono help from the law firm Winston and Strawn. And it's taken 8 years to get to this point because we sued in 2017, and it's not over. We might have to fend off a Second Circuit appeal. So supporting litigation to hold offices accountable is very important. One way is to support and help the New York Attorney General investigate illegal practices. Another way is to give funding and support to nonprofits that bring impact litigation, such as Latino Justice PearlDep and other nonprofits that are speaking today. It actually is especially challenging for civil rights nonprofits like mine that focus on racial justice. There had been hesitancy to support groups recently because some might wrongly accuse them as engaging in illegal reverse racism or supposedly doing illegal DEI efforts, when all we are doing is following the law to help vulnerable people vindicate their legal rights. What we are doing is actually perfectly legal, and supporting impact litigation nonprofits would be very valuable. Another example is we're teaming up with the NYCLU and the Hofstra Law Clinic, and we recently sued Nassau County for their decision to sign on to what's called a 287G agreement to cooperate with ICE. These are all time-consuming cases that are critical to challenge actions that we believe are illegal. All right, now I'm now turning to the impact that immigration policies have on community members, and please type questions in the Q&A if you wish. There are too many questionable policies for us to challenge, and so their impacts on the community. As others have mentioned already, there's more fear in the community, and being afraid is actually justified because there's a greater risk of being detained or illegally arrested, even if you have legal status. Other impacts are there's more anxiety and stress in the community, and that's going to cause more health issues. Some in the community are afraid to go out as much, so they aren't involved with community issues or helping others as much. It's weakening communities. Not going out as much also hurts the economy. And if families don't send children to school as much, their education will suffer. And as many have pointed out, crime victims are less willing to talk to the police, and that weakens public safety for everyone, for all of us. Now, I want to save time for questions. So let me just mention a few things, and I can get into them if there are no questions a bit more. But for now, I'll just mention them. Some steps that would be very productive are that help communities would be to fund immigration legal defense, one-on-one defense to help specific immigrants obtain their legal rights. Another would be to fund impact litigation to bring these larger lawsuits to help groups of immigrants. Also to address detention issues, for example, through ICE Out New York City and Dignity Not Detention. Now, other important areas where we're making efforts are requests under FOIA, the Freedom of Information Act. That's a method to try to get records from the government, and that'll be evidence and proof of what they're actually doing. Also, challenging immigration raids because of their racism and their involve illegal racial profiling. We're talking with many other nonprofits and community groups to prepare in case there are military raids in New York. And we're also raising concerns to international bodies, such as the Inter-American Court of Human Rights. Okay, I've left about 3.5 minutes for any questions. So I encourage people to type some questions. I can also say a few more things if there are no questions.
I just wanted to say, Rex, yes, please don't be shy, folks. If you have questions, do not hesitate. But then, Rex, if you like while we wait to see if there are some questions coming in, if you want to add a bit more, please go ahead.
All right, I will talk slowly so people can interrupt me by typing a question in the Q&A. Like Legal Aid Society, we've also been working with them on opposing challenges to very good, productive New York laws. For example, we filed an amicus brief to support the New York Attorney General's defense of the green light law. And we actually Legal Aid Society represented us in filing an amicus brief about keeping ICE arrests out of the state courts. I don't see any questions yet, so I'll also mention a little more about the FOIA requests. We're involved in 2 different lawsuits, and one of them we are suing because the government is not releasing documents or responding to our FOIA request about their policies for targeting Latinos and targeting Puerto Ricans in their raids and other types of enforcement. And we are co-suing with the American Immigration Council and Democracy Forward for a series of documents and records about what the Immigration Court and ICE have been doing and what their policies are related to those infamous arrests by ICE at immigration courts. So those are just gives you a little more detail of the types of very important areas of making FOIA requests so we can show and expose what the government is doing. Karen, do you have any questions you think I should elaborate on?
Well, actually, I think given our time, I think I will just thank you for your testimony. Thank you so much, Rex, for those remarks. And at this time, I will introduce Shannon McNulty, founder of the Village Law Firm.
Thank you, Karen. And thank you so much, Rex, for your thoughtful remarks. I want to thank you for the opportunity to speak today. My name is Shannon McNulty, and I'm an attorney with the Village Law Firm in New York City. And my practice focuses on U.S. tax and estate planning for clients in the United States and abroad. My practice focuses on advising individuals and families about the legal and tax implications of investing in or relocating to the United States. I also work closely with both U.S. citizens and foreign nationals, many of whom are individuals recruited to the U.S. for their exceptional professional skills in the fields of technology, finance, and management. I'm first going to address the impact of the current administration's policies on foreign professionals and their families. Since the beginning of 2025, I have witnessed a significant shift in how foreign professionals perceive the United States as a destination for career and investment opportunities. Many of my clients originally came to the U.S. because of its reputation as a safe, stable country where the rule of law is respected and merit is rewarded. There are 3 ways I have witnessed the current administration's immigration policies affecting my clients who are legal immigrants. In the wake of legal immigrants being detained or deported for expressing political opinions or for minor paperwork infractions, clients who are here on work visas or even green cards worry about visiting their families abroad for fear of being detained on their return. Before traveling, they seek my advice on precautions they can take to protect themselves and their children in the event they are detained. These clients are also alarmed by the summary arrest and detention of U.S. citizens and legal residents who are mistaken for being undocumented. My clients who are legal immigrants are also hesitant to express and exercise their First Amendment free speech rights, as they have seen legal immigrants targeted for deportation based on political opinions that they have expressed. Several of my clients have made the difficult decision to leave the U.S., particularly where they have the ability to relocate to another wealthy, developed country. These clients, who are both legal immigrants and U.S.-born citizens, cite an increasingly hostile political environment, concerns about the safety of their children, and worries about being unlawfully detained. Families that once envisioned building their lives here are now returning to their countries of origin or seeking more welcoming environments elsewhere. This exodus represents not only a personal loss for these families, but also a brain drain for the United States, which benefits immensely from the innovation, expertise, and investment of these highly skilled individuals. I have also seen the current immigration policies affecting my clients who are American citizens. I'm seeing a marked increase in concern about the stability of the legal and economic environment. High net worth clients are inquiring about moving capital abroad, establishing foreign bank accounts, storing precious metals outside the US, and purchasing foreign real estate to provide a financial hedge and a potential exit strategy for the event of future instability. These concerns are not driven by tax avoidance, but by fear. Fear that the institutions that have historically upheld due process and stable legal systems are weakening. The erosion of trust in legal and government systems leads to capital flight, reduced domestic investment, and ultimately, a weakening of the US economy. Another trend I am observing among my US-born clients is the pursuit of second citizenships, or foreign residency options. A growing number of American citizens, particularly entrepreneurs and high net worth individuals, are seeking secondary passports as a form of insurance. They want the option to leave the country quickly if the political or legal environment deteriorates further. These concerns are particularly acute among my clients who belong to the LGBTQ community. Available data supports what I'm seeing in my practice. The UK authorities report a 50% increase in UK citizenship applications from Americans, putting it at the highest level since record-keeping began. Likewise, Ireland has seen a 96% surge in Americans applying for Irish passports. In my practice, I see the cumulative effects of immigration and economic policies not as abstract statistics, but as real decisions made by real people. Families uprooting their lives, businesses redirecting their investments, and citizens quietly preparing exit strategies. The trends I mentioned are not something I have witnessed in my 20 years of the legal profession. They reflect a loss of confidence in the long-term stability of the US system, a system that has been seen as a global model of freedom and opportunity. The United States has long been a magnet for talent, capital, and innovation because of its commitment to the rule of law, respect for human rights, and opportunity based on merit. When those principles are perceived as being under threat, the repercussions extend far beyond politics. They affect our economy, our communities, and our global standing. I urge policymakers and the legal community to recognize these impacts and reaffirm our nation's commitment to the contributions of immigrants, due process, and the protection of individual rights. Only by doing so can we restore the confidence of those who have long viewed the United States as a beacon of stability and justice. Finally, I am very sorry to say that simply appearing here today and testifying on these matters requires considering my personal safety and the potential for professional retaliation by the federal government. That is a chilling thing for me to even acknowledge. I never thought that I would have to take these considerations into account in making a public statement in my capacity as a lawyer in this country. But unfortunately, that is the reality that we live in today. Thank you very much.
Thank you, Shannon, for your testimony. I would like to call Sienna Freeman Tolbert, partner at Whiteman Osterman Hanna LLP.
I'm here.
Oh, you here? Oh, well, I think we have a switch. Rosie, I may have switched you around. I think if we could have Sienna speak next. Thank you, Sienna. Welcome.
Thank you so much. I want to make sure I stay on top of our time here. Thank you for having me. I appreciate the opportunity to be here. My field is, right now, majority of my practice, easily about 80% is employment-based. And so a lot of my clients are higher education institutions, pharmaceutical and technical companies, and organizations in the healthcare industry. So that's my base. And what I'm going to talk about a little bit today is how my clientele and their employees visa holding employees have been impacted. And I'm going to start by discussing how they've been impacted outside the country, even before they enter, and then what happens once they're employed and what's happening here on the ground in the US. So even before the visa employees enter, so individuals that the hospitals have hired, individuals that my higher education, my colleges and universities have hired, professors, postdocs, all of these individuals are coming to the US to research or to work. And before they even get here, but at the consulate, what we've been experiencing, the first issue we've been seeing a lot of is the entry or visa suspension. In the first administration, we called it simply the travel ban, but now it's the entry visa suspension. And now we have certain countries that are completely banned. They either have a full or partial suspension on entry and visa issuance. And we've seen that in countries such as Afghanistan, Burma, Chad, Republic of the Congo, partial bans in Burundi, Cuba, Sierra Leone, Togo. Those countries, individuals coming from those countries, have very difficult times even getting their visa to come to the US, even before they have the opportunity to be here in the country and work for our employers. And furthermore, in addition to these visa suspensions, travel for our existing employees. So individuals, visa employees who are currently in the US and working for these institutions, their ability to travel and come back to the US have been implicated. Their ability to go to conferences and come back to the US have been highly impacted by these entry and visa suspensions that we experienced in June 2025, pursuant to that order on June 9th, 2025. So that's the first hindrance that we're seeing in general outside the country, just when people travel and when people are trying to come in. The second hindrance that we're seeing among my clients is expanded screening and vetting. As you know, on June 18th, 2025, the Department of State announced in a press release entitled Announcement of Expanded Screening and Vetting for Visa Applicants. They wanted to vet everything, including their online presence of all student exchange visitor applicants and F, M, and J non-immigrant applications. This means when my visa nationals go to apply for a visa, they're disclosing all their social media handles. And we know that's going to be screened and vetted, and we're seeing issues there as well. We're also seeing, before individuals can come into the US, we're also seeing a lot limited third country processing. And that's been a huge issue recently. So basically, when one of our visa holders wants to go to Canada instead of their home country to get a new visa, that's been limited and prohibited by many of the consulates, by the Department of State. And so we've been seeing that impact as well. And that's been really, really hard on a lot of our visa national employees who are currently in the US and want to travel to conferences and go see family. But moreover, it's been very hard for individuals outside the country who maybe got their degree in a different country and they want to process there. In order for them to process in that third country, they have to prove that they have some kind of residency or connection to that country, and that can be difficult. And so as you bring it closer in, now we're talking about the impact on the clientele in my field outside the US. Now you bring them in. As my clients come into the US, they're feeling that stress as well. And I'm just talking about the port of entries. Whether it's you're entering by land or by plane, we've been feeling the crunch and the anxiety there as well. Individuals are very nervous. We start at the very US citizens are calling us, what's going to happen to me when I travel through JFK or Newark or the Atlanta airport? Will they be able to take my phone? What kind of rights do I have at the airport? Should I travel with my work laptop? Those are the types of questions that we're entertaining right now. And that's just before they even enter the country. And that's from US citizens, green card holders, and then into our visa holders. They're all very concerned about what's going to happen when you enter the country. What kind of rights do they have? And whether they'll be, if it's a visa holder, turned around. If it's a green card holder, whether they will be detained. And if it's a US citizen, whether they will confiscate some of their mobile technology, if you will. So that's the strain we've seen just on the journey of our for our visa employees coming from outside the country just to come in, and other individuals traveling in and out the country. We've been seeing that stress a lot as well. In addition to that, now we're here, we're in the US. We recently had the proclamation that came out for H-1B visas. And the presidential proclamation required a $100,000 supplemental fee with new H-1B petitions. And so that caused a little bit of chaos in our field as well. We now know that that only applies to new applicants who are coming from outside the country and coming inside the country. However, that has impacted our higher education institutions on whether or not they recruit from outside the country. That has impacted our pharmaceutical and technical companies on whether they recruit from outside the country, and more so even in the healthcare industry, where many medical professionals, lots of medical professionals come from outside the country on H-1B visas. They have been impacted as well. So their ability to come into the US and practice without being subject to the $100,000 fee is in question. There is an exception to that rule, the national interest exception, but we haven't seen how there hasn't been a full adjudication of the national interest exception. So we're all waiting with bated breath to see what that looks like and what are the parameters there. But that has been a huge hindrance, and we're seeing a lot of departments and different industries changing the way they hire based on that, and preparing themselves not to hire individuals from outside the US. And that is unfortunate to be happening in our country, because we're definitely going to feel the repercussions of that, because we won't have the best and the brightest at our university any longer when we're not allowed to bring individuals from outside into the US to do research, much needed research, and so on and so forth. So that's where we're at with that. But as of October 16th, 2025, the U.S. Chamber of Commerce and others sued to block this fee. We have no final court outcome yet, but we expect that there will be an injunction. We expect there will be a lot of litigation around this $100,000 fee. And so we're really watching that very closely, because that will have a high impact on what's happening in terms of H-1B visas in many industries. And I think people fail to realize how many industries that touches. It touches, like I said, your higher education institutions. It touches your medical and your healthcare industry, and it also touches our technical and our pharmaceutical industry as well. All right. Another thing that we're seeing that's unique in the employment-based world, but as someone that used to do removal work, I was not surprised, but it is interesting. So what happens is, when a student is transferring from an F1 student visa to an H-1B visa, or when an H-1B visa holder gets laid off from their job and they're going to another employer, they have a 60-day grace period. What we've been seeing over the last couple months is, during the 60-day grace period, they've been issuing notice to appears to our H-1B visa holders and other F1s who are in a grace period. And this has caused a heightened anxiety amongst our H-1B visa holders, our F1 visa holders. The idea that you can be placed in immigration court during your 60-day grace period, while you may be looking for new employment or looking for your new school, trying to figure out what your next visa will be. And so we've seen that happen. And as we know, the logistics behind going to court, getting that closed, is just extra headache. It's an extra work on and extra anxiety having to go to court. And so we've been seeing that as well. And we've seen the issuance of those NTAs. We haven't been seeing as much detentions, but I expect that's going to go hand in hand, and we'll be seeing that very soon. But that is something very new in our field that we've been dealing with. And we've been trying to prepare individuals who are laid off from a position that they may, issuing an NTA and getting a notice to appear is something that may be an option now. We've also been having a lot of discussions with our healthcare industries and our higher education institutions specifically, because the sensitive area memorandum was rescinded on January 20th. And in the past, the sensitive area memorandum would protect, the correct word, it would encourage non-enforcement in sensitive areas such as schools, places of worship, funerals. They would typically not do enforcement in those areas. Well, that has been rescinded, so now that policy is gone from ICE. And so we've been talking a lot with our institutions that used to be covered by that memorandum about what they do in the interim. Specifically, what makes it so important is like, what do you do at a graduation? You know, whether or not an individual can ICE just walk, if it's open to the public, can ICE walk in a graduation at a high school and just ask questions because it's open to the public? Sporting events for schools, is it open to the public? Hospitals, the waiting room, emergency waiting rooms open to the public, but which waiting rooms aren't open to the public that ICE could not just walk in and ask questions? So it's a lot of conversation around that. Where are Fourth Amendment rights? What is our line on the Fourth Amendment rights? When is it gray? When do you need to put more signage up to make it clear that an area is not open to the public so you don't have ICE enforcement in those areas? So those are some of the conversations we're having right now with my clientele due to the sensitive area memorandum being rescinded recently. I think I have 1 more minute, so I'll do one more thing. And I want to talk very briefly about we expect some rulemaking to happen in early 2026 regarding green cards for our researchers, our individuals filing for extraordinary ability, and people who had green cards based on national interest. And so these are just really highly educated individuals who've done a lot of research and publications, and they've been filing to receive a green card. And we expect that there will be some rulemaking in January 2026 to limit the ability of these individuals to be eligible for those activities. So we are really concerned about what's going to happen academically with our researchers in the U.S. with all of these hindrances to get into the U.S., as I discussed earlier, all these hindrances when you're trying to change your status during a 60-day period, getting a NTA, and then the ability to get a green card for our researchers. What does that look like too? So we're watching to see what happens, but we're really concerned about what happens academically for those institutions. Thank you.
Thank you so much, Sienna, for your testimony.
Welcome.
Our next and final speaker will be Rosie Wang, Program Manager of the Vera Institute for Justice. Welcome, Rosie.
Thank you so much, Karen. Good afternoon, everybody. Thank you for the opportunity to testify. My name is Rosie Wang. I'm a program manager at the Vera Institute of Justice. I'll be testifying about the policy solutions that can help address the unprecedented need for legal assistance in our state caused by heightened immigration enforcement and detention in New York State. Over the past year, New York has seen detention rates increase at alarming rates, with the federal administration intensifying and escalating attacks on our immigrant communities. Vera is a research policy and advocacy organization that works to end mass incarceration, protect immigrants' rights, ensure dignity for people behind bars, and build safe, thriving communities. A core priority of our work is advancing universal representation to ensure that no immigrant is forced to face detention and deportation without access to legal counsel. Since the start of President Trump's second term, New York immigrants have been subjected to unprecedented attacks. Vera's analysis of data from the Executive Office of Immigration Review shows that as of August 2025, detention rates doubled over the last year. Also, as of August 2025, more than 100,000 cases before New York State Immigration Court are unrepresented. That is, over 1 in 3 people are facing deportation without legal counsel. Between January and July of 2025, ICE arrested nearly 5,000 New Yorkers, arresting more people in those 5 months than all of 2024 combined. And this surge is just the beginning, unfortunately. In 2025, the federal government allocated an additional $170 billion for immigration enforcement, enabling ICE to recruit thousands of new agents and massively expand their capacity for immigrant detention. These developments endanger not just the rights and dignity of immigrant New Yorkers, but the well-being of everyone across the state. Immigrants make up a quarter of the state's workforce, including over 190,000 entrepreneurs. More than a third of New York's children have an immigrant parent. This rampant enforcement threatens the stability and security of communities, of family unity, and the state's economy at large. Against this backdrop, it's more important than ever for New York State to ensure that people have access to legal counsel and to mitigate the harms of the detention and deportation system. There are several common sense proposals that address this: the Access to Representation Act, the BUILD Act, the New York for All Act, and the Dignity Not Detention Act. Additionally, New York must significantly increase annual state funding for immigration legal services. Together, these policies would create a right to counsel in immigration court, expand the capacity of legal service providers to serve more people, and reduce the harm of immigration enforcement systems. We thank the New York State Bar Association Committee on Immigration Representation for supporting these policies and hope that Bar Association leadership will help amplify these priorities in the year to come by calling upon the state to pass these bills. To explain a bit how each bill addresses the emergency at hand, first, the Access to Representation Act, or the ARA, creates a right to counsel in New York State immigration courts, where today people are left to navigate life or death cases alone if they cannot afford a lawyer. Without representation, we do not have a fair or just legal system. Individuals represented by lawyers in immigration court win their cases at rates up to 10.5 times higher than those without legal assistance. The ARA would be implemented through a multi-year phase-in approach and via a universal representation model, meaning it would bring a public defender system to immigration court. It would also ensure that New Yorkers transferred to other states by ICE, away from their home and loved ones, still receive counsel. At a time when enforcement is drastically intensifying, it's more important than ever to ensure that New Yorkers have lawyers by their side to help defend their rights and remain with their families. New York must also pass the Building Up Immigrant Legal Defense Act, or BUILD Act, which would provide a dedicated investment in capacity building for the immigration legal services system in our state. Passing BUILD would fill critical gaps in the current infrastructure, like understaffing and lack of access to counsel and legal deserts. This in turn would also lay the groundwork for a robust immigration legal services field capable of actualizing the ARA's right to counsel. This investment would fund DOJ accreditation programs, hire experienced supervisors, add social workers to support attorney work, and recruit and sustain expert staff. This kind of support is essential to stabilize, strengthen, and grow capacity of the immigration legal services field to effectively meet this increasing need. ARA and BUILD are long-term permanent policy solutions that ensure New York is ready to meet the needs of immigrant communities, both in the current landscape and for years to come. But as we fight for these bills to pass, we must also ensure that in the interim, legal service providers get the resources they urgently need and immigrant communities get access to the help they urgently need. We asked the Bar Association to support a $175 million investment in immigration legal services through the Office of New Americans, also known as ONA, for fiscal year 2027. ONA's current $64.2 million in funding in fiscal year 2026 falls short of what's needed to meet this critical moment. Of this $175 million we recommend that $85 million be used to strengthen and sustain providers currently providing immigration legal services under Office of New Americans contracts. We recommend allocating $50 million to launch new deportation defense efforts in response to sharp increases in enforcement. And we recommend that $40 million be used for capacity building, strengthening the ability of legal service providers to serve more people in a sustainable way. This investment is not only necessary for protecting New York communities, but it's also fiscally smart. A study by the New York City Comptroller found that providing statewide access to counsel for all people facing deportation would generate an estimated $8.4 billion in net benefits for federal, state, and local governments. By passing this funding alongside the ARA and BUILD Act, New York could once again also be a nationwide leader in protecting immigrant communities. In 2017, the New York Family Unity Project became the first statewide publicly funded deportation defense program in the country. Since then, more than 10 states have followed in New York's footsteps because of this success. Finally, New York must also pass the Dignity Not Detention Act and the New York for All Act to ensure that fewer people are subjected to the harms of detention and deportation in the first place. The New York for All Act disentangles ICE from state and local agencies, prohibiting the use of state or local resources for immigration enforcement. The Dignity Not Detention Act ends and prohibits detention contracts between New York State and ICE. By reducing New York's support for detention deportation and the harms that they cause, we can also ensure that fewer people require legal representation in the first place. Together, these measures can keep immigrant New Yorkers safe and ensure that legal teams defending them are resourced to respond to urgent needs. The importance of New York State's leadership in upholding freedom, fairness, and family can't be overstated. Legal representation is a lifeline, not only for the well-being of immigrant communities, but all communities across the state. We ask for help in calling upon the New York State to pass $175 million for immigration legal services and the ARA build New York for All and Dignity Not Detention. Together, we can ensure that New York is a state where everyone can thrive safely at home, in their jobs, and with their families. Thank you so much for your time and attention.
Thank you so much, Rosie. So I want to, on behalf of the Committee on Immigration Representation and the Immigration Working Group, I'd like to extend my thanks to today's speakers, whose testimony provided critically important information and insights about the impact of the dramatic changes in immigration and policy and enforcement, and recommendations to address that impact in communities across New York State. I just want to really extend my gratitude to all of you in helping to capture a very rich and detailed account of the huge diversity of impacts and the breadth and depth of those impacts across the state, and the need for action to protect our communities, our profession, and the rule of law. I'm very grateful to you all. I wanted to be sure to let folks know that we welcome additional written testimony in addition to this hearing. And if you or others you know are interested in submitting written testimony, please email either Eunice Benka or myself, and and we'll distribute that email after this session. Thank you so much for everyone for testifying and for those who have attended today. That's the end of the program. Thank you, everyone.